Hello, I'm Joe, and I'll be talking about how disabled men and women in the United States fought for their civil rights and the struggles that they endured. And it all started in 1973 with Section 504 of the Rehabilitation Act and this banned discrimination of men and women who receive federal funds from the government. This act had a big impact because it recognized disability barriers, which would be lack of education and lack of job opportunities for disabled men and women. And another big impact that this act had was it recognized these disabled men and women in a class or a majority group, which they previously were recognized as individual diagnosis. And after this act, in the 1980s, advocates for the ADA fought for civil rights that had been stripped by negative Supreme Court rulings. One of the big cases was the Southeastern Community College versus Davis. This was a hearing impaired woman was denied admission to a nursing program because of her disability. The results were Supreme Court was ignorant about Section 504 and was misinterpreting it and actually using it against court cases with people with disabilities. After this, in 1988, they held joint hearings in with the Senate and the House of Representatives, and speakers came from across the country to state their claim about how they were discriminated against. And a couple key stories were a woman with breast cancer couldn't get another job because she had a history of cancer, and a man with HIV couldn't be buried because he died of HIV. And after this, lawyers and advocates answered repetitive legal issues by drafting a bill that would answer some of these issues. This bill was the Americans with Disabilities Act. This was passed in 1990, and it was the first law that gave civil rights to the disabled, and this entailed the physically, mentally, and disease-ridden. Americans with Disabilities Act, it was the first comprehensive act that gave civil rights that included the needs of people with disabilities, prohibiting in the workplace. And the terms of this act were it wouldn't be implemented until 2 years after, in 1992. And because the laws had to be created and businesses had to be educated about them, and the changes under these, businesses had to accommodate for these disabled people as customers and employees. And this act actually helped many disabled men and women do lawsuits, and settled 91% of the lawsuits within the next 8 following years. And the new and you, disabilities are more common in the workplace now than ever. Businesses must accommodate for all these disabilities. Small businesses are encouraged to accommodate these disabilities by tax refunds, and they give tax breaks for if you have a certain amount of these quota and people hired that have disabilities. And I work at a restaurant with a few mentally handicapped people, and my restaurant has these accommodations that help out these mentally handicapped or these handicapped people. This is a win-win because it helps disabled people that are visiting and working, and businesses also get tax breaks. And now I'll be introducing Tyler Abbott, who will be talking about burns that are disabled.
Thank you, Joe. Okay, so far we've looked at protection from discrimination against different kinds of demographics and disabilities and other things. So we're going to talk about protecting our veterans now because their rights need to be protected as well. We need to level the playing field for them when it comes to employment. We're going to talk about that. So we have Entergy Corporation, that they had a case with alleged non-compliance with this law, putting vets potentially at risk for discrimination for their employment and their hiring and their advancement. So here's a picture I have for readjustment, reintegration. So the vet's kind of this hand chess piece. The can only move one space at a time, and right now it's facing like the whole other half of the chessboard alone. And for many vets, especially in that time period, they felt this way. So they needed a solution. This came in the form of legislation that leveled the playing field for them, so they didn't have to feel so kind of against the world in this way when they went to reintegrate and look for jobs again. This was the Vietnam Readjustment Act of 1974. It was affirmative action specifically tailored for Vietnam vets. For the readjustment, the reintegration, this made it easier for them to find employment, and it made it easier for them to advance. So it did those benefits for them coming back, readjusting to civilian life and looking for these jobs. Moving forward, what else is there? This is another picture depicting how it must feel to come back to civilian life after serving. So let's look a little bit more into the hiring pool. Talking about this, we're looking more for equal employment opportunity, kind of like how other things are protected in a similar way. So getting to the PMFs and the interviews and the jobs and having equality there for vets, very important. Okay, so entered the Department of Defense that had an alleged noncompliance case. They were actually found to be compliant with the law, but it's important that the vet still had the right to pursue this in court, because the solution that he needed was legislation for equal employment opportunity. I have an equal sign representing the equality. And so this was very beneficial to him when he was pursuing this. Executive Order 11478, unlike that Readjustment Act, this is a little bit more general. It has parts of it that include accommodations and protections for vets. But it's more general, it's a blanket legislation for other groups as well. Recapping those two, the Readjustment Act, it specifically but it helped out in particular the Vietnam era vets who were coming back to civilian life, and that was a very specific thing for their needs, bless you, for the federal contracts. Looking at the Entergy case over again, they were required to have an affirmative action plan that they failed to submit, so that was part of their settlement. They needed to help with employment and advancement for people who they were hiring. The Department of Defense case, looking at that again, they were found to be compliant, but as I said before, it's important that the vet had the right to appeal. We'll talk about more about why that's important in just a second. But they were found to, they already had the affirmative action plan. So we have two types of laws that help Vietnam era vets. So we have that Readjustment Act, again, that's specifically to this group. It's specifically created with them in mind, as opposed to the executive order that is a little bit more of a blanket term, but includes provisions for vets as they enter rehiring and employment. Okay, so this is important to me because I do have family and friends who serve, and they fight overseas and domestically to protect our rights. So with this and supporting laws like this, I think that we can protect their rights as well in turn, which is about the least that we can do. So they have those two laws that help them reintegrate and get reemployed. And at this time, Andre, who is, I believe, a Navy reservist, he's going to talk about a little bit more recent legislation that applies to most people serving today.
All right, so I'm Andre. I'm going to be covering the United Services Employment and Reemployment Rights Act of 1994. For short, I'm just going to call it USERRA for the rest of the presentation. It's used to protect the rights of reservists and guard members who would be called to active duty. So some of the topics I'm going to be covering is reemployment rights, pension coverage, and discrimination. Now, there's other topics that USERRA covers. However, these I felt pertain to human resources. All right, so here we have Scott Harrison. He's an Army reservist. He served multiple years in Kuwait, Afghanistan, and Iraq. And when he came home, he realized the company he worked for didn't give him any promotions, and his career didn't accelerate. So how did they discriminate against Scott Harrison? Well, according to USERRA, when a member of the armed forces comes back from active duty, they're supposed to get the job back swiftly with the same seniority, pay, and status as they were previously. So in the case of Maxfield versus Centas Corp., again, we have another Army reservist who felt he was discriminatorily transferred after he returned from active duty. Now, he didn't lose any money, but after a while, he was discharged, and he felt it was because of his military obligations. Now, USERRA says an undesirable transfer is considered denial of a benefit of employment. His previous job gave him job stability and bonuses, and now his new position, he received nothing. So, as far as discrimination is concerned with USERRA, during initial employment, retention, and promotion, all of those, you're supposed to be free of discrimination, as well as any other benefit of being employed. So, USERRA defines an employer as any successor in interest to a person, institution, organization, or other entity, and we'll talk more about that with these two cases coming up, Reynolds versus Rehab Care and Murphy versus Communications. So, in the first case, both of them provided the same service, but it was a government contract. So once the plaintiff went on his active orders, his job lost the contract, and then a new company came in and hired his co-workers. And the reason he won this case is because due to the new company hiring old employees, they said it was a continuity of a business, so Murphy was hired. In this case, it's similar to that one. Same services were offered, however, the new company didn't take any of the old staff and they didn't use any of the old equipment. Therefore, Reynolds in this situation lost the case because there was no continuity of business between his former employer. So that right there covered the pension benefits. Whenever a member of the reserves leaves on military orders, the employer is supposed to allocate to the pension just the same way they would do with any other employee. So in Scott versus Absolute, we have Scott was on military orders, and he realized that once he returned, his employer didn't give him any of his benefits for his benefit plan as he should have. Therefore, Scott won this particular case. In Archo versus Central States, we have a part-time employee for UPS. He went on active duty orders and came back thinking he deserved to be, should have had his contributions. However, UPS only does contributions for full-time employees, therefore he lost. This applies to me for the reason posted. I'm a Navy reservist. I'll talk about some of the questions I get, the reactions I get from employers, and some of the assumptions that employers have. So as far as being a Navy reservist, at any time I can be called to active duty. It's nice to know that we have laws like this that I personally wasn't aware of. But for those that have families, to know that your civilian side job is protected when you come home is definitely a plus. When I go to look for a job, you get questions such as how long are you supposed to serve for, how many days will you miss of work, and are there any other availability issues? It's kind of a pain when you have a college schedule, plus you have other obligations. It's kind of hard to find a good part-time job. So as far as reactions go, some employers are happy to know that you're military, while others aren't so thrilled about it just because they know you're going to miss days of work, regardless of the reason. And that's something to just deal with. With the assumptions, most employers assume that since you're in the military, you're disciplined, you won't be late for work, you're detail-oriented, and truthfully, we're all just people, so that's not the case. And that concludes our presentation.